passing that authority.
Okay. So number one, before I even go any further,
It
it's
is
not
really
legal
cute.
advice, right? This
Not
is not
legal
legal
advice.
advice. Not legal advice. We're just reviewing.
Yes.
We're just looking at the statute and the code to see if there's a consistency with what the state process is doing, or
Correct.
what even possibly the local municipal county court might be doing, right?
Correct.
Like, is it in alignment? Like, because my initial question in regards to this was like, okay, so you have like how like from my perspective, from my understanding, how the whole system operates is you have a federal statute or a constitutional law, right? From the federal statute or the constitutional law, you also have what are considered precedents and examples of cases that have already occurred that align itself with certain laws that are being challenged, all right, or subject to question, right? So along with that, there's usually an administrative order or an administrative process that must be adhered to before the case can even be heard, right? So let's say that we're dealing with a case where what's going on, this is like, possibly, let's create a scenario. So a child was, let's make it a child situation, right?
A child was abused, abandoned, or
Is being
neglected.
is allegedly,
Allegedly abused, abandoned, or neglected.
right?
State does an initial investigation,
Mm-hmm.
maybe over a few days,
Mm-hmm.
sometimes a few weeks, until they come to their determination that it is in the child's best interest to be sheltered from their caregiver.
Okay. So
Primary caregiver.
so here's some of my first questions, right?
Yes.
Some of my first questions are because there's an injured party and there's a witness and there's an accused individual, right? So the accused individual had to have been witnessed, or had been someone had to testify or like made a statement against the defendant,
Correct.
or the accused in this situation to for that type of situation to even be begun, right? So who made the call?
They're anonymous
Was
most
it
of the time.
was it the child?
Usually not
It was anonymous party.
anonymous.
How is the anonymous party like?
Sometimes they're identified, sometimes they're not, just depending on who. I mean,
Okay,
if they
so
want to
like
be
in
or
order
not.
in order for like an individual or like the accusant to even like find out who it was that even accused them
A lot
of
of
the
the
of the part of the act of the allegations in the court process, regardless of it, like, because this person's already in court right now, they can depose the state to name who the witness is, or just depose the witness in general to corroborate or to confirm the testimony, because it's a one-sided argument without the witness to the injury, right?
Mhm.
So like there's one particular violation, right? Secondly, now let's continue to move on, because like without the witness, without the someone, an injured party to challenge, once again, like you can't I can't provide any kind of relief or remedy. Like like if I need to pay somebody, like who am I going to pay? Who's anonymous? You know what I'm saying? Bring anonymous here, because like at the very least I need to be able, I have the right. I have the right to face my accuser, right? Is that a federal statute, or is that a state
That's
statute?
federal.
That's federal, right? Okay, so that's a federal right, right? A violation of due process. It
Yeah.
is a violation of due process. It's absolutely a violation of due process. So move on forward, right? What else
Okay.
is violating?
So they come to the conclusion that child should be sheltered.
Mm-hmm.
The statute says, I'll get to the what it is. Jurisdiction over the child attaches upon any of the following taking place when the initial shelter petition, dependency petition, TBR petition, or petition for an injunction to present child abuse issued pursuant to section
Okay, so was the
So,
child being housed in a shelter?
well, this is, the child is home, and this jurisdiction over them attaches when when this initial shelter petition is filed.
Was the parent and the child in a shelter when the petition was
No,
filed? No?
no, they're
Were
in their
they
home.
are they were in whose home? Their own
Usually
home?
their own home.
Okay, so they were in their own home, right? Like so like were they like seen smoking or in what was presumed to
Not
be
usually by the
cannabis?
CBI, not by the CPI usually.
So okay, so let's look at that, right? So like
They allow
number two,
hearsay. This,
so number two, the third party or the party acting on behalf of the anonymous party, right, has filed a petition without having firsthand knowledge or without being able to confirm the accuracy of the testimony of the anonymous party. That's also another violation to due process, is it not? It certainly
yes.
seems to be. I mean, because like we don't know, but it's a question that we would have to ask, and we would have to petition the proper venue to determine, right? So like we're determining whether or not like the accusing party is, right? We're confirming whether or not the testimony of the accusing party was accurate by the third party or the second party filer, who is being represented by CPI, right? The Child Protective Institution or whatever the hell they're called, right? So has CPI given whatever state related attorney accurate testimony or verified statement towards the accuracy of the testimony of the anonymous party for them to initiate and file a claim against the accused? That's three things. So there's three questions of accuracy already being presented.
And we'll add a fourth one in there. So the petitions, other than being filed before being able to take the child,
Mhm.
they are not filed till the next morning, and they
Mhm.
take the child. And there is a petitioner, good faith affidavit on the back for them to sign and date, and that is also not dated until it is filed that following day.
Okay.
And so there's no, even if that was notarized and whatever, there, which would kind of help them out.
Right.
That,
Well,
that
then-
doesn't happen, so there's no probable cause, even unheard by the court,
Mhm.
like, 'cause it never goes really heard, but the probable cause is never even determined, it's just the CPI, whatever they want to do.
Well, okay, so while it might still be whatever the CPI might want to do, right? They're still doing it through the attorney. So they're directing the attorney to do what the attorney is doing. The attorney, if the attorney filed any documentation or any complaints or anything else like that without having an accurate testimony or verification of an accurate testimony or the importance of the documents that were filed, the dates on of the petitions, the timeliness of the petitions, and whether or not they fit into the statute of the time frame mandated by the federal government or even the state government, right? Because if they weren't, then the untimeliness of the petitions filed may be enough to also have the petition denied in its entirety against the state's attorney. Because once again, like the administrative order, if the administrative order that's supposed to be adhered to, right? Like there's an administrative order 413-11. I believe it's administrative order 431-11, maybe 411-11. So, but if you look up that order says that it's based on a regulation from the Supreme Justice that it was created in 2010, and it says that the petitions must be verified by the opposing or the moving party's attorney, and the attorney has to have confirmation or properly notarized document verifying the testimony of their client, right? Then moving on with the state, or even with the timeliness of the petitions that are filed, if they're not filed in proper time, that may also be enough to have the motion denied. But then you also go back to the initial challenges of whether or not like the testimony is accurate, that's also being passed on, because like without the witness to the injury or to the damage or the abuse to the child or the neglect of the child, like there's no case. You understand? There really is no case. And so like any kind of statements or filings that are being made in a civil court, like essentially like that's like treating it like it's a landlord tenant court. If it's not, especially like in the state of Florida, from what I understand. I'm not a lawyer, so I don't understand.
Juvenile court.
Okay, so even
So
in a
it's a civil
juvenile
matter that
that
follows
involves
the rules of
that
juvenile
involves
procedure.
a juvenile. So like okay, so but still the juvenile rules
are criminal, correct?
I mean, they're saying like
The
yes,
juvenile
they
procedure is
could be
criminal?
they could be criminal, right? Like because if the child is engaging in some of the activity, you know what I'm saying? And so like if the state is joining the
Yeah.
actions of the child with the
Yes.
actions of the accusing party, then they're like saying like the
Correct.
child is guilty by
And
association.
so that's where or juvenile court gets its jurisdiction
Okay,
from, correct?
then so is the attorney on file for the child, or is it for the accused who said that they did who's said to or allegedly suspected of child abuse and neglect?
Well, for the state.
It's for the state, but is it for the
For
child?
DCF.
Okay, it's for DC,
And DCF,
but they're the
state
plaintiff in this
gives
case,
that
right?
authority to DCF to make those decisions. That's
But,
who they
okay,
grant their
but-
authority to.
but
Those
DC
are their actors or their
But
agents.
DCF is saying that they're a witness to child neglect, right?
Yeah.
But they're a secondhand witness, because the primary witness is anonymous, right? So they have to have firsthand knowledge, and they have to have witnessed the injury. Like, was there even a drug test performed on the accused?
Well,
And
they,
once
and
again,
then,
are
then
they
you have
is
the
it
drug tests that aren't admissible in a court. If you were going to trial with something, they're just a standard drug test that doesn't get sent out to a lab.
on
and
the
those
case
aren't,
on the case file? Does it say the state versus the parent and the child, or does it say the state on behalf of the child?
it says, in the interest of
The child,
the child,
the state,
the children.
the state in the interest
Yeah,
of the
yeah.
child. Okay, so
Yeah.
like,
Well, the circuit court
let me see.
for Palm Beach County.
No, see, like in this, like the case hasn't even started yet. This is still like a preliminary hearing.
Yeah, but they have the children in their custody already. And this was before
Okay,
this was
so
ever even, there was never, so at this initial hearing, shelter hearing, the state determines whether or not there's probable cause to shelter the children. Okay, so realistically, a parent can say, no, we're not talking to you. You're not taking my child. You're going to go to court first and have a judge say that you need to come and talk to my child. But the state, I mean, DC, the CPIs ask questions. The parents are afraid. So they respond because they
but
don't
it's
want to
not.
get
But
in trouble.
okay,
No,
but
and then
it's
they
hold
wind up
on a second
acquiescing
though.
to
Like,
everything.
what do you mean
The whole
parents?
entire
Because it
process.
says that there's an unknown father.
Well,
So it's the mother with a boyfriend.
yes. Well, the mother, I mean, that's one specific, I mean, I don't even know if I've read that one, but
This isn't the case?
I mean, they're all generally similar to
Similar.
that, very similar.
Okay, but like, you know,
They
like,
make reasonable efforts to find the father. They ask the mother in court if they.
okay,
I mean, you know,
so
like
in
a
the
standard
particular
question
case
is-
that you were talking about, right? It's a mother versus a mother. It's a similar case to this versus a mother, right?
The
Is
one
is
there,
this is
the
this
severing
is
one?
this the case or no?
No.
Show that one.
Actually, that might be.
Because like here it is that once again, like
I think this is the one.
if the state is filing in and
Yeah,
for
this
the
is the
interests
one.
of the child, like, you know, did they get a statement? How old is the child, and did the child give them a statement?
No, but
Did the child, you know,
we
provide
have one
a?
that's 8.
The child is 8. No, give me the case that. Give me the specifics. Don't do that to me.
No, this is the one.
Don't do me like that. You
I
know
mean,
how
that's the one
you
that
know
I
how
was
you
talking
change up
about
the scenario
that
every
I,
now and then.
that I
Yeah,
was
you
thinking.
tricky.
I was thinking was like a severable case, and then there was no way that there wasn't anything for them to take this child on.
Yeah, okay, so even still with this one, this is a preliminary hearing, right? Because they're still saying, they're still counting themselves as the petitioner. So here it is that like the mother needs to object to the petition and file a complaint against the petitioner. But still, even when she files her complaint, the next initial step is to finish filing her complaint with the federal government as the plaintiff, right? Because they would have the proper jurisdiction to hear this case. Now, if they don't, like, this is still in and for the county of this particular case, right? Like, so it's still being treated like a civil juvenile matter. Like, it's still not even in the state's court, right?
But is that not kidnapping the children?
It essentially,
Without, like, I mean,
essentially
I
it
just-
is, but like, you know, but like
I know,
you,
like,
but like
nobody-
in this venue, you can't make the accusation or counter challenge of kidnapping if you're not
arguing.
complaining, if you're not complaining. You know what I'm saying?
And when you complain to the federal.
You would complain to the federal, and then if the federal would say, you know, this is a case that's not in our jurisdiction, it's supposed to be in the state's Supreme Court. Let the state Supreme Court handle it. Well, then it'll come out of the county's venue, and it'll go to the state court, and in the state court, you'll still have made the proper challenges for you to get the necessary relief,
And now, while
which is return
now
custody
you
of the
have
child.
though a child, but why? Now, okay, you get the return custody, but what about the entire time that all that is taking place, and so they have a
that's what you
definition
call
within
that's what
that
you call
statute.
damages, like you
so
know.
and they have specifically within the statute mental injury.
That is so.
And-
That's part of the damages that the mother should consider filing, you know, against the opposing party. You know, the petitioner in this case, you know. So like the petitioner you know, like if the documentation is filed properly, from what I understand, you know, like you go like I would strongly suggest that she ask her lawyer, you know, because she has a state issued lawyer. So ask the lawyer, like, shouldn't this be X, Y, and Z? You know what I'm saying? Like, aren't like, and if it is, like, you know, this shouldn't there also like the actions of the petitioner, are those not, you know, possibly kidnapping? Isn't that also like human trafficking? You know, that's also depriving the mother to her rights of, like, you know, to her child, like, you know, like those are questions
And
that
traumatizing the child.
yeah, like, and that's injury, you know, like those are damages that are compensatable by, like, you know, or that are compensatable by reward of relief, whatever the court might feel. And in most cases, it's, you know, in this day and age, it's monetary. You understand? Like, it's always going to be monetary. It's never going to be like, oh, like, we're going to fire somebody. No, you're going to get paid. You know what I'm saying? Like, and not paid, like, you can never get paid for the type of damages and the pain and suffering that a person is going through. And I mean, like, that is traumatizing. It also, like, violates, you know, and invalidates the
child and their parent
the
relationship.
child and their parent,
Their
the
parents are
parent,
bad.
and not to mention, like, you know, the trust that they might have in state government regarding issues like these. You know, like, how do you know that government or, like, this agency is not going to commit the same thing? You know, like, we're the administrative orders, need to be seen. Like, and I mean, if at the very least with her complaint, like a request made under the Freedom of Information Act. You know what I'm saying? Like, for real. Because they're a federal agency, essentially, if they're dealing with children, right?
Right.
Like, so then, like, if they're a federal agency, then they should be like, and you need to know what their requirements are, what their processes are, with like how it is that they go into carrying out this order, carrying out these activities where they basically kidnapped the child. You didn't have probable cause, you didn't have a witness, like.
And they don't necessarily tell the parents what's in the petition even before they take the parents go to court, and they
have to request it though. Like, see, like that's like once again, like people who even what happens is that when an individual receives a state or like pro bono attorney, right? The pro bono attorney only goes so far, and they're only familiar with the rules of their specific court and their specific venue. They don't really ever go outside of that. Very rarely do they ever go outside of that. Now, like is that negligence? Is that like an issue of ineffective counsel? Possibly. That could definitely be a possible issue of ineffective counsel, because the attorney's job is to do the very best that it can for its client. And if it's not, then I mean, like, why are you supposedly helping me? Like, you're not doing anything. Like, furthermore, you're supposed to inform me of all of my rights underneath the law, not just the local municipal county law, not just the state law, but the federal, as well as like if the person's not even a citizen of the country, right? Then like that's an international thing.
Yeah, and
because that should be
a lot.
Yeah, and like so like even with deporting, yeah, like what's been going on in the media lately, right? Like even those children, even think about that. Even in those instances, the children are still being given an opportunity to sit on the stand and defend themselves. And they're asking 2-year-olds and 3-year-old children, do you understand what it is that we're telling you? And they have headphones on, being with a translator in their ear telling them stuff. And you're asking a 2-year-old to make a decision for themselves. But still, even under international law still has to be administered on this proceeding, because they're not citizens of the United States or even members of the Corporation of America. They might be members or nationals to the continental landmass, and so under international law, United Nations Declaration of Rights of Indigenous People, women and children have the right to equal treatment under the law. Preservation of culture, right? A right to defend themselves or even to face their accusers in criminal matters. I mean, like, there's lots of information out there already, but like challenge in the proper venue, and then shit rolls downhill. So like throw your shit to the fucking top instead of like trying to push a turd ball upside the damn thing. Put it in a catapult. That catapult being a complaint with the necessary challenges, and you could look at the United States District Court's website and then review their information and get something of substance versus watching a fucking Atari ping pong game on 2D when you got an HD TV kicking 1080p.
I'm old school.
Like you still got antennas and pliers turning the handle. But yeah, don't forget to like, subscribe, share, comment, all that stuff. We out of here.